Steven start ചെയ്തോ.
In our personal lives, if we do not develop our self-awareness and become responsible for first creations, we empower other people and circumstances to shape our lives by default. Quote by Stephen Covey. Honorable Chief Guest of the Day, Advocate Parvati Prasannan, Respected Principal Dr. Brilli Sangita, dignitaries, teachers, and all my dear friends, good morning. Challenge brings innovations, creativity, and incentives for improvement. Those who initiate change will be better at managing them, even if it is inevitable. I invite Sinna Jilson, IAS IEEE Chaya, to deliver welcome speech.
Good morning, everyone. I am so happy to see you together here. A big thanks to each and everyone for joining our today's session about intellectual property rights, organized by IEDC and IEEE student branch of IES College of Engineering. And it's my privilege to welcome you all to this wonderful session. First of all, I would like to welcome today's resource person, Advocate Parvati Prasannan, an intellectual property rights attorney, first rank holder in both LLB and LLM, specialized in trademarks and copyright law, and a powerful person to handle our today's session. So with great pleasure, we welcome you, ma'am.
Thank you.
Next, I would like to invite our Honorable Principal, Dr. S. Brilli Sangita ma'am, who is the backbone of our college. Even in her absence due to emergency medical reasons, she sends her regards. Then, I would like to invite various head of departments and our faculty team and all the participants to this wonderful session. Thank you.
Thank you, Sinna. IADC in association with IEEE of IAS College of Engineering is here with another goal to provide incentives for innovation for inspiring young innovators of our modern times on the topic intellectual property rights. In the modern era, intellectual property rights plays a significant role on the trade of every nation. In this digitalized world, there are stands of higher risk of creative ideas getting stolen without consent of the author. The need for strong intellectual property laws gives an overall contribution in the economy of the respective state. Intellectual property right is one of the source of security for intangible properties which are still open to the public and which can be replicated by anyone.
Today, we are delighted and honored to have with us Advocate Parvati Prasannan. She is an University of Kerala gold medalist and first rank holder in both LLB and LLM. She has been associated with Putran and Associate, patent and trademark attorney since June 2006, and heads to Bangalore and Kerala operations of the law firm. Advocate Parvati is specialized in trademarks, patents, industrial designs, and copyright laws. She is also an experienced attorney in drafting and reviewing transactions and contracts involving transfer of intellectual property and intellectual property licensing. We desire to hear from you, ma'am. Please.
Thank you, everyone. I hope I'm audible. Thank you, Ajesh, Ajmal, for inviting me as a speaker to this event. It's actually great to see efforts being taken by universities and colleges to promote awareness on intellectual property rights. So for me, it's a great privilege to be part of such a great cause. So thank you once again. As you all, as all of you are aware, I assume this is a specific session for intellectual property rights and part of the faculty development is what I understood. So, so in the next 1 hour, I will be basically engaging with you on intellectual property rights, and my task will be to give you an overview on the different aspects of intellectual property rights, the different types of intellectual property rights, and what is the need or necessity for protection of intellectual property rights. Now, since all of you are, or I guess most of you here are engineers and researchers and scientists, we will focus more on innovations and how to protect your innovations by way of patents. So I have a small presentation that I have prepared. Let me see if I can share my screen. I will need your help to make me the host so that I can share my screen.
Yeah, ma'am. Can you please share now?
I am able to do that. 1 second. Is my screen visible now?
Yes, ma'am.
All right. So, like I said earlier, since our focus will be mostly on innovation and how to protect your innovations by way of patents. So, before we start learning about what exactly is intellectual property, I'm 1 second. I'm just trying to admit in people. There are a lot of people waiting. Since I'm the host, shall I admit them in? I can see a message popping up on my screen.
No, ma'am. We will handle it.
Okay, all right. So, so we will. So before we learn the different aspects of intellectual property rights and how they are protected, especially patents, let's just learn what exactly is innovation. I'm sure all of you have heard of the term innovation. So let's start learning with what exactly is an innovation. How do you know that you have innovated or you've invented something? Now, as you can see on the screen, these are some of the very famous innovations that the world has seen. On the right hand top corner, you can see Thomas Alva Edison and his innovation, which is called the electric lamp. So one of the greatest inventions that the world has ever seen. So this is a very classic example of an invention or an innovation of the old times. Down here, you can also see the Wright brothers, who invented, whose innovation is called flying machine. Both of these are patented inventions. Electric lamp was patented as early as in 1880, and flying machine was patented in 1906. Walt Disney was another innovator. As we can say, his invention is titled The Art of Animation, which is also a patented invention, which was patented in 1936. How many of you knew that Michael Jackson himself was an innovator? He holds a patent for an innovation that we made. It's called a lock mechanism. His patent is called the method and means for creating anti-gravity illusion. It's actually a lock mechanism that he invented in his shoes, which helps him do the tilt act. I'm sure all of you must have seen the tilt act that Michael Jackson does when he performs on stage. So this he does with the help of a certain lock mechanism in his shoe, which is also a patented invention called method and means for creating an anti-gravity illusion. So this is just to give you an idea of some of the innovations that the world has seen. So what exactly is innovation? Now, innovation is as simple as taking something that is already there and then you transform it into something that is useful for the society or that creates wealth or that has some utility for the society. And if you're doing any of this, already an innovator. And all you need to do is you have to think out of the box. So innovation is as simple as taking something that is already there and then you change it to something that is useful for the society. And innovation need not be something very big. It something as small as a safety pin. Even a safety pin is a patented invention. It need not be something very new, something absolutely new. It can also be an improvement of what is already there. As you can see, the transformation of a wheel. So it need not be something that is absolutely new. It can be something that is an improvement or a significant change in what is already there. It doesn't really matter, but all innovations start from an idea. That is what matters. So all innovations, if you look at all innovations, it all starts with what is called an idea. Now, what are the 3 steps to innovate? So if you look at any innovation, there are 3 steps for you to innovate. They are ideation, creation, and validation. Now, let's see what these, each of these steps are. So the first step is ideation. Now, all innovations start from an idea. So you have an idea in your mind, and then what you do, you discuss it with your peer group, and you understand that this is a great idea. So that ideation is the first step of innovation. The starting point of any innovation is having an idea in your mind, which you think is a great idea. Now, the next step is creation of an idea. What is creation of an idea? Now, when you have the idea in mind, when you think that it is a great idea, or you feel that it is a great idea, you toss around the idea, you work around that idea, you experiment on that idea, and then you materialize that idea into something that is usable or something that is workable. So that is the next step of ideation or next step of innovation. That is, after you have an idea, you create that idea, or you transform that idea into something that is workable or usable. Now, the last step of innovation is validation. How do you validate your idea or validate your product that you have created? You get people to use that invention, or you get people to use your idea. It is tested, you protect it, and once it is approved by the people who are using it, your idea makes some sense, and it will also help you realize value out of your idea. So that is when it becomes an innovation. So all innovations, like I said earlier, starts with an idea in your mind. So I put this question to you. Think about it. What is your idea? Think about how you can transform that idea into something that is, you can transform that idea into something that is workable, something that can be useful for the society, and something that can realize value for. Now let's move on to the main part of our session, which is intellectual property rights and specifically patents. Now, so this is what we will discuss today. We will learn what exactly is intellectual property rights. I'll give you a brief overview on the different types of intellectual property rights. Then we will move on to one specific aspect of intellectual property rights, which is patents. We will discuss what is patentability, that is what are patentable inventions, what are not patentable inventions. We will discuss what exactly is a patent search, why is a patent search important, and finally the patent filing procedure. How do you file a patent? Once you realize that, or once you find out that your invention is a patentable invention, then how do you file a patent? And then finally, why do you need to patent your innovations? So this is what we will discuss during the next 1 hour. Now, what exactly is intellectual property? I'm sure all of you know what is an intellectual property right. Just like the word indicates, intellectual, or so it is a creation of your mind. So intellectual property is a creation of your intellect, or creation of your mind, and it is an intangible asset. Unlike your house or your real estate or a piece of land that you have, which are all tangible assets, intellectual property is an intangible asset. And as far as businesses are concerned, intellectual property is an asset for any business. Now, what do you need to do with this asset? If you have an intellectual property, what do you need to do? What do you do if you have a real property? What do you do if you have a piece of land or a house in it? You probably, you will develop that land. You will probably build a fence around it. You will maintain it. You will upgrade it, so that it realizes value for you. In the same way, if you are the owner of an intellectual property, right, your intellectual property also has to be maintained, it has to be developed, it has to be used, and it has to be protected if it has to realize value for you. So if you don't do this, then there is no value for your intellectual property. Now, what are the different types of intellectual property rights? There are different types of intellectual property. For example, there are trademarks, there are industrial designs, there are patents, there are copyrights, there are geographical indications, there are trade secrets. These are all different aspects of intellectual property rights. So we will quickly go through the other aspects, that is trademarks, industrial designs, copyrights, and geographical indications, and then we will move on to patents in detail. Now, what is a trademark? I'm sure all of you are familiar with these images or these names or these logos that you see here. A trademark is basically, it can be a word, or like, let's say Toyota or Pepsi. It can be a symbol or a logo like the swoosh design of Nike, or the three-pointed star symbol of Mercedes-Benz, or it can even be a slogan, like, for example, "Just do it," which is a tagline or the slogan of Nike, or "The taste of India," which is the slogan of Amul. So it can also be a product packaging or the design that you see on a product. Like, for example, this particular design that you see on the product packaging of KitKat, that itself is a trademark. So all these are examples of trademarks. Now, what is the purpose of a trademark or a trademark as an intellectual property right? Now, let's say you're going to a supermarket and you want to buy a soap for yourself. How do you identify? How do you identify which is the product that you want? You identify that by either some name on the product packaging, or some color scheme on the product packaging, or some symbol on the product packaging, which will help you identify the product that you want. So basically, the main function of a trademark is to identify the source of that particular product. So when you see a particular mark, when you see this logo on a car, you know the source of that car, which company the car comes from. Or when you see the swoosh design on a shoes, you know the shoes is made Nike. So trademarks are actually source indicators. The moment you see a trademark or a which can be a word, a symbol, or sometimes even a color combination, right? If you see the purple color combination, the purple color on a chocolate, you know it comes from Cadbury. So basic function of a trademark is to help the consumer identify the source of that particular product. And in many cases, you can also say that a trademark is also an indicator of the quality of a particular product. When you look at a product, when you see a trademark, you know that that particular product has a certain level of quality because it comes from a certain source. So trademarks are indicators, or they are names, slogans, or symbols, or color combinations, or packaging designs which help consumers identify a product or a service of one company, or the source of a particular product or a service. Now, what about copyright? What is copyright? Now, copyright is another aspect of intellectual property right. Now, copyright actually exists in literary, dramatic, or musical works, or artistic works that are created by you, cinematographic works, and sound recordings. So all these are subject to copyright. Now, copyright subsists in original work. So if you create something that is original, which is a literary work, dramatic work, musical work, or an artistic work, or a cinematographic work, or you make a sound recording, all these can be protected under copyright. Now, copyright as a very term indicates, what copyright protects or rather prevents is copying of that work by somebody else. So if somebody else using his own intellect creates something, even if it is similar to your work, if there is no copying, then there is no copyright infringement. And in copyright, the first owner of a copyright can only be an individual. Copyright cannot, the first owner of a copyright is always the author of the work, or the person or the persons who have actually created that particular work. Unlike trademarks, trademark can be owned by a company or a partnership firm or a legal entity. But a copyright, the first owner of a copyright is always the individual or the author who has created the work. So these are the categories of work in which copyright subsists. And like I said earlier, what copyright prevents is actually copying of a work by somebody else. Now, the next intellectual property right is design or industrial design. So what is industrial design? Now, industrial design refers to the external shape or configuration of some eye-appealing or aesthetic feature of an article. So let's say if you have invented a chair or a bottle with an absolutely new shape, not available to the public anywhere in the world, then you can actually protect the shape of that bottle, the shape of that chair by registering it as a design. So industrial design. In design, what is protected is the configuration or the shape of that article and not the way that that article functions or the functionality of that particular article. So what is protected is the outwardly appearance or the shape or configuration of that article. It is, and this particular shape should be an integral part of the article. These are all these are different aspects of intellectual property rights which are entitled to protection, but what they protect is entirely different things. As far as trademarks are concerned, they protect their symbols that are used in commerce which indicate the source of a product or a service. They can also be registered and protected. Copyright refers to the intellectual property rights that applies to works of creativity, something that is created by you, like literary work or a poem or a story that you have written. In fact, in India, computer programs are also protected by copyright. So copyright protects works of creativity. Design protects the shape or configuration or some eye-appealing feature or aesthetic feature of an article. So all these are different categories of intellectual property rights which can be protected by way of registration. Now, another category of intellectual property rights is geographical indications. I'm sure all of you must have heard of geographical indications and different examples of geographical indications. So geographical indications are certain names or tags or symbols that are used on agriculture, natural or manufactured goods like handicrafts, wherein the particular product has some unique quality that is linked to the geography where the product originates. A classic example would be champagne. Now, champagne is a certain variety of sparkling wine that originates from the Champagne region in France. So the quality of the wine is attributable is because of the quality of the grapes that is grown in the Champagne region of France. Similarly, Scotch whiskey is another example of a geographical indication. Kanjipuram silk or Varakulam pineapple is another example of a geographical indication. Kashmir Pashmina. I'm sure all of you must have heard of Pashmina shawls that come from Kashmir. What is the peculiarity of this particular cloth? Now, this cloth is actually made from the wool, the undercoat of a certain variety of sheep that is found only in the high altitudes of Leh Ladakh region in Kashmir. It is the peculiarity, it is the high altitude, it is the peculiarity of that wool that gives pashmina the certain quality or the softness or the lightweight that the product has. So these are all examples of names where the product has a quality that is attributable to that particular geography from where the product actually originates. These geographical indications are also intellectual property rights which can be registered and protected. Now, unlike the other aspects of intellectual property rights like trademarks, patents, copyrights, and designs, it can be individually owned. Geographical indication is a community right. It cannot be owned by an individual or a company. Geographical indications can be registered or can be owned only by the producers, the group or association of producers of that particular product. So geographical indications is a community right, whereas all others are individual rights, that is trademarks, patents, designs, and copyrights. There are also other aspects of intellectual property rights like trade secrets. Trade secret is actually, I'm sure all of you must have heard of trade secrets. Trade secret is some information that is very critical to a business, which it does not want to publish, which it wants to keep it as a secret. There is no law in India that provides for registration or protection of trade secrets. So as long as the business keeps it as a secret, it will be protected. The moment it is divulged or it is disclosed to someone, the secrecy is lost. So they are also examples of, they are also, valuable intellectual property rights, which the owner wishes to keep as a secret. An example of a trade secret would be Google's search algorithm. is an example of a trade secret. It's not known to anyone. Another example is the New York Times bestsellers, the bestseller list as to how they choose the bestseller. That is also a trade secret which is not available to anyone. So these are information. Trade secrets are also valuable intellectual property rights which the owner wishes to keep a secret and does not want to divulge to the others. Now coming to the next aspect of intellectual property right, which is patents, which we will discuss more in detail. Now, what are patents? Patents are the intellectual property rights that relate to inventions. Now, patent is basically an exclusive right. It's a monopoly right that is granted to someone who has invented something. So if you invent something, you have to disclose your invention to the government, and the government, after checking a lot of things, will give you an absolute monopoly right or the exclusive right for that invention. And what does this exclusive right give you? This right helps you, once you have a patent for something, you can exclude others from making, using, or selling or importing that patented product or a process. Now, this exclusive right that the government gives the patent owner or the owner of the invention is for a limited period of time, and it is also territorial. The territorial means if it is protected in India, or if your patent is granted in India, your protection is only valid within the territory of India. And finally, these patent rights are statutory. Now, what do you mean by a statutory right? A statutory right is a right that is granted by law, wherein if you don't have a patent, there is no protection for your invention. Unlike copyright is an automatic right. The moment you create something, the moment I write a poem or a story and I transform it into a piece of paper or a computer, I have copyright over it. My copyright is already protected. Whereas for patent, it is the other way around. A patent or an invention becomes a patent only when it is granted as a patent by law, by the government. So it's a statutory right. So if you don't patent your invention, you cannot claim that it is your patent. So patent is a statutory right where the protection applies only when a patent is granted to an invention. Now, what are the laws in India that governs a patenting system? Now, patenting system in India is governed by the Patents Act of 1970 and also the patent rules of 2003. Now, where do you file a patent? If you have a patent, if you have an invention and you want to file and protect it as a patent, where do you file it? There are 4 patent offices in India which are located in Kolkata, Mumbai, Delhi, and Chennai. This is where you file your patent applications, depending on where the applicant is based. If the applicant is located anywhere in South India, then the appropriate patent office where you have to apply for your patent will be the Chennai patent office. The patent offices come under the Ministry of Industry and Commerce. Office is in Bombay, which is a Controller General of Patents, Designs, and Trademarks. The other offices are in Kolkata, Kolkata, Delhi, and Chennai. There are 5 trademark offices in India, and there's only one copyright office which is in Delhi. So if you have to file and register a copyright, you have to file it in the Delhi Copyright Office. There's only one copyright office in India. Whereas if you have to file and register a trademark, you have 5 trademark offices from which you have to choose the appropriate trademark office. Patent offices, like I said earlier, there are 4 patent offices in India located in Kolkata, Mumbai, Delhi, and Chennai. Design, if you want to file and register an industrial design, there is only one designs office in India which sits in Kolkata. So this is where you file your patents. Now, who can apply for a patent? Now, as far as intellectual property rights, the first owner is always the person who actually creates that, right? So in an invention also, for a patent also, the first right is with the true and first inventor of that particular invention. So the inventor himself or the inventor, or if there are more than one inventors, the inventors jointly can file a patent application for protecting the invention. Now, what if the inventor is working in a college or a university or working in a company, and the invention was developed by him as part of his employment with the company or part of his research, which was undertaken in the college or the university? Then he will have to assign his invention to the company or the college or the university, and then the university, the assignee, that is the university or the company, can make an application. Finally, if the inventor is dead, then his legal representatives also file an application for a patent. Now, coming to the most important question, are all inventions patentable? No, an invention is patentable only if it satisfies three important criteria of patentability. Because only if it satisfies these three criteria will it be considered as a patentable invention. Now, the first and foremost criteria for patentability is novelty. Novelty means newness. So your invention to be patentable has to be new or absolutely novel, which means it not have been published anywhere in the world before the for filing of a patent application. So even if you're filing your patent in India, in one particular country, for it to be patentable, it should be new across the world. So even if it is disclosed in some other country, or if it is there, disclosed in some other patent that is filed or used in some other country also, you will not be able to get a patent in India. The novelty aspect of an invention or newness of an invention for the purpose of assessing patentability is searched or is assessed across the world. So absolute novelty across the world is a primary or the most important criteria for patentability of an invention. So which means if you yourself publish your invention before filing a patent, you lose the novelty of your invention. So no publication. So absolutely no publication or newness of the invention is the fundamental criteria for patenting an invention. Now, the next criteria for patentability is called inventive step. The inventive step means non-obviousness. That is, your invention should not be obvious to a person who is skilled in that particular field. Now, let's say your invention is in the field of mechanics. So it should not be, your invention should be such that a person who is skilled in that particular field or skilled in the field of mechanics should not have thought of. So if he feels that, oh, this is something that, I could have also thought of, or this is something that I could have also achieved, then it becomes a non-patentable invention. This is a very subjective criteria and difficult to prove if, raised as an objection by the examiner. Because if the examiner, when a patent is filed, the examiner is always chosen from from that particular field. So if the examiner feels that, there is no inventiveness, your invention is very obvious to a person who is skilled in that particular field, then it becomes a non-patentable invention. So your invention may be novel, there may not be any prior publication. Your invention may be absolutely novel, but it should also have some inventive steps, some significant improvement from the existing technology, which should not have been thought of by somebody who is, who has a reasonable skill in that particular field of science. Finally, industrial applicability. That is, your invention should have some use or some utility in the field or in the industry. And there's also another criteria which is linked to industrial applicability. That is usability or workability of an invention. Now, when you file a patent, how we draft a patent application is, we draft it in such a way that the examiner who reads the patent application should be convinced that it will work, because it is not possible for you to carry your prototype to the examiner, show him that this will work. No, that is not possible. So by reading your specification, the examiner should be convinced that it will work, or it will work the way you claim it will work. Right. So workability and usability are also very important criteria for patentability. So if you cannot convince the examiner that this will work, the way you claim in the specification, then it becomes a non-patentable invention. So workability and usability are also very important criteria for patentability of an invention. Now, apart from these three criteria, main criteria for patents, there are also a lot of inventions that have been specifically notified as non-patentable inventions under the Patents Act. Section 3 of the Patents Act lists down a lot of inventions that are per se not patentable. So if your invention falls under any of these lists of inventions in Section 3, it becomes a non-patentable invention. For example, anything that is contrary to public order or morality, or something that affects an invention that affects the health, or which causes damage to human life or plant life or generally environment, becomes a non-patentable invention. Invention also has to be differentiated from discovery. Now, discovery means something that is already there. You discover something that is already there, whether it's a living thing or a non-living thing. Discovery of a substance that is naturally occurring, that is also not a patentable invention. Discover only a new form of a known substance or new use of a known substance. Some substance is already known. Your invention is that this can be used for a new purpose. That is not a patentable invention. You're simply mixing two substances. Let's say there is a compound A which has certain properties. There's a compound B which has certain properties, both of which are known. You just combine the two and then say, the combination has the properties of both A and B. That is not a patentable invention. Any method of treatment of a disease or diagnosis of a disease is not a patentable invention. Plants and animals cannot be patented. Agricultural and horticulture methods also cannot be patented. Then anything that is part of traditional knowledge, anything that is already disclosed in the ancient Ayurvedic texts, or especially therapeutic effects of medicinal plants, all these are part of traditional knowledge which also cannot be patented in India. Now coming to some general informations for inventors, as potential patent holders or filers of patents, there are certain things that you need to keep in mind before you think about patenting before you start the patenting process. Now, the first and foremost thing is that you should always maintain records of your research work. Now, when you're doing research, the outcome of your research activities may be something that is potentially patentable. Now, these records you maintain as part of your research work are very important because they help patent attorneys draft the specification of a patent. So always maintain records of your research work because they form valuable information for patent attorneys to draft the specification of a patent. Second important point is something that we already discussed, that is, do not publish your invention before filing a patent. If you publish your invention, then you lose the first and foremost criteria for patentability, which is novelty. So you yourself publish your invention, there is no novelty for your invention. So do not publish your invention before you file a patent application. So if you do a research and your development, your research and development shows that there is potential patentability, then you file a patent for that invention and then you publish your invention. So publication should be done after you file a patent application. There is no objection to the secret working of your invention. For example, if you work your invention in a lab for the purpose of trial and everything, those will not be considered as an impediment or will not affect the novelty criteria of your invention. Now, another important point that needs to be kept in mind is always conduct a patent search before you apply for a patent for an invention. Now, we will discuss what patent search is and what is the importance of conducting a patent search before filing a patent in the coming slides. So, patent search is basically to assess the novelty of your invention. You may think that your invention is absolutely novel. Nobody must have, invented something like this, but there's every chance that something very similar may have been disclosed in some other patent document somewhere else in the world, which could affect the novelty of your invention. So conducting a patent search is also a very important aspect of the process of patenting an invention. The next is a very important point that has to be kept in mind, that in patent, it is always the first to file that has priority over an invention. Now, the reason for this is that, like I said in the first slide, that patent is a statutory right. Patent or an invention becomes a patent or becomes protectable as a patent only if you have a patent for it or a granted patent for it. For the same reason, it is always the first to file that has priority. So let's say, for example, you have an invention, you file it today. If somebody else has applied for the same invention yesterday, then you will not get a patent for your invention. It's always the first to file or the first person to apply for patent that will have a priority over the invention. For this reason, it is always advisable that you apply for a patent as early as possible. Now, which is why we always advise our clients not to wait for the entire research or the development of the prototype to be complete to file a patent application. You can actually file a patent application the moment you have an idea in mind and the idea has taken a concrete shape. So you have an idea in mind and you know that this idea is going to work, is going to transform into something like this. At that point of time, you can file a patent application. We call it a provisional application, so that you don't have to wait for the next, several months to complete the research and then file a patent application. So by filing your patent application as early as possible, you're actually lodging your priority with the patent office. So anybody who comes with an invention after the date of filing your patent application, will not be a threat to your novelty of your invention. So always file a patent application as early as possible, because the more you wait, for your invention to be developed into a prototype, the chances of you losing the novelty of your invention are much higher. So filing the patent application or the provisional application as early as possible is a very important aspect that needs to be kept in mind in a patenting process. This patent document, we call it a patent specification, is a techno-legal document. So it's very important that a patent is drafted, the specification and the claims are drafted very carefully. So it's very important, or it's always advisable to choose a patent attorney. The do-it-yourself approach to patenting process may not be advisable. When it comes to, intellectual property may not be advisable when it comes to patent, because there's a lot of effort that needs to be put in when it comes to of a patent specification and claims. It's very important that the claims and the specification are drafted, with clarity, so that your invention is adequately protected. So selecting a right patent attorney for drafting your specification is also a very important aspect of patenting process. Finally, even after your patent is granted, you have to keep your patent application alive by paying the necessary annuity fees and all that. So keeping your patent application alive is also an important aspect. And finally, one of the most important aspects is that, if you don't commercialize your invention, let's say you have a patent for something, if you don't commercialize it, it is just a piece of paper. Patent is just it will just be a feather in the cap for you. So unless and until you make commercial, or you commercially exploit your invention, there is no value for it, or it just remains piece of paper. So it's very critical that you also ensure maximum commercial exploitation of the invention if you have to realize value out of it, or if you have to get investments on returns for the investments that you have made on your invention or your research in that particular invention. Now coming to patent search, let's see. So we discussed earlier, about why patent search. What is patent search and why is patent search important? Like I said earlier, patent search is an important aspect of patenting process. Now, what is a patent search and why is it so important? Why is it important why is it necessary to do a patent search before you file a patent? Now, what is patent search? Patent search is often referred to as a prior art search. You may have heard of this term, prior art search. Now, what does prior art search means? Now, the word prior means earlier or existing, and art means knowledge. So, prior art means earlier or existing knowledge. So, in prior art, what we search is, in a prior art search, what we search is, we search for the existing knowledge or existing technology in that particular field. Now, where do we search for existing technology? We will search for prior art or the existing technology in patent documents, patent documents of countries, such as, a lot of the patent databases of most of the countries are available for free. So you can search in patent databases of countries. You can search in scientific journals. You can search in publications, books, magazines, etc. So all these are databases where we search for prior art. Now, why is a prior art search important? Why do we need to do a prior art search? Now, one of the main reasons why patent attorneys do a prior art search is to check the patentability of an invention. So if somebody comes to us for filing a patent application for an invention, we have to, first of all, before you invest a lot of money into the patent filing process, we need to check if it is a patentable invention, right? We need to know whether there is some disclosure somewhere in the world, some other patent document, some scientific journal, which can affect the novelty of your invention. So to check the novelty of your invention or to check the patentability of your invention is one reason why a patent search is done. So doing a prior art search helps you identify what is the closest technology, what is the closest prior art in your field. Let's say you have invented something, something very new in a certain field of science. So by doing a prior art search, you can identify which is the closest prior art, which is the latest development in that particular field of science. And thus, by identifying the existing, prior art or what is already there, you can prepare your patent application or your patent specification in such a manner that you can clearly differentiate how your invention differs from the existing prior art. So this actually helps. So doing a prior art search not only helps you analyze the novelty aspect of your invention, it also helps you file a stronger application because you can clearly define in your patent application as to how your invention is different from the existing invention. Or you can even, once you do a prior art search and you identify the closest prior art, you also have an option to do further research, make some modifications to the invention and then file a patent application. So it helps. So doing a prior art search actually helps you file a stronger patent application. And yet another reason, important reason why patent searches are done is to check for infringements. Let's say, for example, a company is planning to launch a new technology into the market. What if that technology is already patented by somebody else? Then the launching of that technology would be an infringement of somebody else's patent and can, land that company into a litigation. So before a lot of companies, before they launch a product into the market, do a patent prior art search to confirm that their product or their process or whatever does not infringe a third-party patent. So checking for infringements or checking whether the invention or their product, confirming that their product does not infringe a third-party patent is also another reason why a patentability search is done by patent attorneys. Finally, a lot of companies do patent searches to understand their competitors' portfolio. Like, for example, if I am Samsung, I would always want to know what research Apple is doing in respect of mobile technology. So the only thing that I need to do is I need to do a search for the patents filed by Apple. So I can know. So these patents, contain the latest scientific development in a particular field of science. So a lot of companies do patent searches to analyze or to understand their competitors' research, their competitors' portfolio, the research that is happening in their competitors' company. Now, this is just to give you a quick example of an interesting case to give you an example of why patent searches are important. Carl Kreuer was a Danish inventor who invented that a sunken ship can be raised from the bottom of the sea by filling that ship, the sunken ship, with buoyant objects from the top of the water. And once you fill in with the buoyant objects, the ship will rise up to the bottom. Rise up to the top. So this was his invention. So he thought this was a fantastic invention, and nobody has invented something like this. And he filed a patent application before the Netherlands Netherlands patent office. But contrary to what he thought, his patent application was rejected because the examiners at the Danish patent office actually found out a very old issue, a 1942 or 43 issue of a Donald Duck magazine, wherein Donald Duck was seen using the same invention to raise a sunken yacht from the bottom of a lake. Donald Duck was seen filling the sunken yacht with ping pong balls from another chip on the top, and then he was seen racing the sunken yacht. So this particular magazine and the picture therein was cited as a prior art by the Danish patent office examiners, and the patent was refused by the examiners at the Danish patent office. So this is just to give you how a prior art can affect the novelty of your invention, and how you can lose the chance to patent an invention because of a prior art. Now, what do you need to do for a search? All you need to do for a search is a computer, and you need search engines or search databases. Now, that there are different search databases or different databases where you can actually search for patents. There are a lot of free or open source databases like Google Patents, Lens, Free Patents Online. These are all patent databases which are available for free. You can use keywords to search for inventions in any of these free databases. Then patents are also searched in patent databases. Prior art searches are done in patent databases from of the different countries. Most of the patent databases of most of the countries are available for free. For example, the Indian Patent Office database is INPASS, which is a free database. You can use keywords to do a search. USPTO is that of the United States Patent and Trademark Office, which is also a free database. Then Patent Scope is the database of WIPO, the World Intellectual Property Organization, again a free database. eSpaceNet is that of the European Union Patent Office. So all these are patent databases of countries which are available for free. Then there are also paid databases which are subscribed to usually used by patent attorneys such as PatBase, Questel Orbit, Patseer, etc. These are paid databases which are usually used by patent attorneys. Now let's let's see how a patent filing is done. Now we know what a patent is. We know that it is a statutory right. We know what is patentable, what is not patentable. We know the criteria. So once we analyze and find out that okay, this invention qualifies for filing a patent, we proceed with filing a patent application. So let's learn how a patent is filed. What is a filing procedure for a patent? Now, the first procedure for filing is a filing of the patent application or drafting of a provisional or the patent application. Now, like I said earlier, there are two ways in which you can file a patent application. Let's say, for example, your invention is not fully ready. I'm sure you remember me telling you that, in a patent, it is always the first to file a patent that has priority, and that it is always advisable that you file a patent application as early as possible, right? So in that context, it is possible to file what is called a provisional application for a patent. So you have a certain idea in mind, you've done a lot of research, and you know that your idea is going to take a definite shape. At that point of time, you can draft and file a provisional application for a patent. Now, filing a provisional application actually helps you establish the identity or your ownership of the invention as early as possible. So you don't wait for the entire research to be complete, for your prototype to be developed to file a patent application. Even before that itself, you can file a provisional application. Now, in a provisional application, you don't need to disclose the entire features of your invention. You just need to give a broad outline of your invention based on which you can file a provisional application. Now, once you file a provisional application, you have a time period of 1 year to file the complete application or the complete specification of your invention. So after you file a provisional application, you have 1 year time period to complete your research, and then prepare a complete specification of the invention, and then file a complete application. So you will get a filing date from on your provisional filing date. So your filing of your patent application or the filing date of your patent application will be the date of filing the provisional application, which helps you lodge an earlier priority. Whereas if you don't file your provisional application and you wait for another 5 or 6 months or 8 months to file an application after your research is complete, there are chances that somebody else may have filed something that is very closely similar to your invention, which can affect the novelty of your invention. So it is always advisable to file your patent application with the provisional specification as soon as you have a certain idea in mind and the idea has taken a definite shape. And then once you get that filing date and the filing number, you continue with your research, complete your research within 1 year, and then file the complete specification. Now, complete specification, unlike the provision, is a very detailed disclosure of your invention, where you have to give title, you have to specify the technical field in which the invention relates to, you have to give the background of the invention, which is where we give the prior art, results of your prior art. This is the background of the invention. What is the problem in the prior art? How is it solved in your invention? The object of your invention, and then you describe your invention with the help of drawings. And then and then finally, how your invention works. What is the best method of performance of your invention? And finally, you end the specification with the claims. Claims are the most critical part of your invention. So what you claim is what you get a patent for. So what is the newness? So all the novel aspects of your invention will be part of your claims. And finally, you end with an abstract of the invention. So complete specification is a very detailed disclosure of the invention, which is given within 1 year from the date of filing a patent application. Now, what happens once you file a patent application? Once you file a patent application, for the first 18 months, your patent is kept a secret. Nobody knows that such an application has been filed. Now, after 18 months, the patent office will publish your invention in a journal called the Patent Office Journal. It is possible for you to file. It is also possible for you to file a request for early publication of an invention. Also, sometimes some inventors may want the public to know that an invention or a patent has been filed for an invention. So you can actually file for an early publication. If you don't file for an early publication, your invention will be published only after 18 months. So within that 18 months time period, nobody will have any access to your invention. Once published, your complete specification, your drawings, the applicant details, the inventor details, everything will be made available to the public. Now, after the publication of the invention, the next step is called examination, where your patent office or the examiner will examine your patent application and find out whether your invention is capable of or entitled to a patent. Now, this process will happen only if you file a request for examination before the patent office. Now, this request for examination will have to be filed from within 48 months from the date of filing the application. So, when you file a patent, whether it is with a provisional specification or a complete specification, all dates are calculated from your filing date. So, publication happens after 18 months of the date of your filing the patent application. Request for examination has to be filed by you within 48 months from the date of filing the patent application. If you don't file a request for examination, then your patent application will be treated as abandoned. Now, what happens when you file a request for examination? When you file a request for examination, the examiner at the patent office, who is usually a person who is skilled in that particular field of science, will examine your application. He will first of all see, if all the formality requirements are met with, then he will assess the invention. He will do a prior art search on his own, and he will see if there are any criteria for criteria for patentability that is not satisfied by the invention. And then he will, once that assessment is made by him, he will give you a very detailed report called the first examination report, or the IPR, which is communicated to the applicant, saying these are the objections against the trademark. So if he finds any prior art that he thinks affects the novelty of the invention, then he will list down all those inventions. Then if there are any other objections related to non-patentability, like if the invention falls within any of the inventions under section 3, which are non-patentable inventions, also those can be cited. So once you get the applicant gets the first examination report, he has a time period of 6 months within which he has to respond to it or file a detailed response to the examination report. If you don't file a detailed response to the examination report, then your patent can be refused. Now, if you give a satisfactory report to the patent office and the patent office requires any further information or any further clarification from you, then the patent office can also, call you for a hearing before him, for giving you an option to explain and argue your invention in detail, argue as to why your invention qualifies for a patent. So your patent attorney will attend the hearing and then, discuss the matter in detail with the patent office, pursuant to which, either the patent may be granted or refused, depending on depending on whether you satisfy the criteria for patentability. So this is how a patent goes into a grant. Now, once a patent is granted and an order is passed that a patent is granted to you, your protection runs for 20 years. The exclusive rights that you have runs for 20 years. And this 20 years starts not from the date on which the grant is passed, but from the date on which your patent application is filed. So the date of a patent, so when you say your patent is granted, the date of a patent is not the date of grant, it is the date on which a patent is filed. So your protection also runs from the date on which the patent application is filed. Now, apart from, once your patent is granted also, it is very important that you keep your grant or your patent alive by paying the required annuity fees. Now, annuity fees for patents have to be filed from the second year of the patent up to the 20th year. It has to be paid every year. So that is also another important, very important thing that needs to be kept in mind. Annuity fees has to be paid every year from the second year of the date of the patent. So I hope the filing process of patent is clear to you. Now let's see why do we need patents? Why do we what is the importance of filing patents, or the significance of filing a patent? So the first and the most important reason why people file for patents, or inventors file for patents, is the exclusive rights. Now patents actually provide the inventor the absolute monopoly right or exclusive rights for 20 years. So during the period of, so once your patent is granted for 20 years, you have the exclusive right to use that particular invention, right? So this exclusive right actually gives, as far as businesses are concerned, this exclusive rights give them a very strong market position, because they can prevent others from using that invention, right? So through these exclusive rights that they get, we can prevent others from commercially exploiting or using that patented invention. So they can reduce competition. You can actually establish yourself as a very important player in that particular market. So giving patents or exclusive rights granted by patents gives businesses a very strong market position. Now again, if you commercialize, if you're able to commercialize your invention, you can actually get returns out of the investments that you have made on the invention. So let's say if it's some a new technology, there'll be a lot of investment that you make towards research and development of that particular product or the particular process, right? So once it is patented and you can get an exclusive rights over it, you can get higher returns. If you commercially exploit your invention, you can get higher returns on the investments that you have made on that particular research. Now, let's say if you are an individual inventor and you have invented something, you have patented something, you may not be able to manufacture it in large scale and then sell it and all that. But you can always, even if you're not able to manufacture and sell your invention, you can always license your patented technology to an interested party, and then you can get a royalty out of the sale. So you have an opportunity. So a patent owner need not necessarily manufacture and sell the patented product on his own. He also has the opportunity to license or sell his invention to somebody else and get benefit out of that particular sale or license. Then finally, as far as universities or any inventor is concerned, patent is actually, having a patent in your name is definitely a positive image for your enterprise. If you're a company, business partners, your investors, your shareholders always consider, a company having a patent portfolio as a demonstration of, the expertise or high level of expertise or specialization, or even the technological capacity of the people in that company, or the inventors, or the technological capacity of the inventors. And this can prove, having a patent portfolio in your name can, as far as any business is concerned, can be very useful for raising funds, or finding business partners, or in fact increasing the market value of your company. So it's definitely a positive image for any enterprise having a portfolio of patents in your name. Finally, the most important point: if you don't patent it, somebody else can patent your invention and prevent you from using your own invention. Now coming to what is the purpose of a patent? The fundamental reason why we are looking at patents. Now, the very purpose of a patenting system, if you see it, is actually to encourage innovation, because it grants inventors, and once a patent is granted for an invention, you get an exclusive right, like we discussed. So this patenting system is actually like a contract with the government, where the inventor will disclose his invention to the government, and the government will give you an exclusive right to use that invention for a particular period of time. Now, after that particular period of time, just 20 years for patents, after the 20-year time period, then your invention is available for the public to use that invention. So the exclusivity is actually granted in the exchange of your disclosure of the invention to the public, right? If you have invented something, and if you want the patent for that invention, if you want an exclusive right for the invention, it is mandatory that you disclose the invention to the government, right? The government will disclose it to the public. But once you get a patent, you have the exclusive right for 20 years, and after that it goes into public. So what happens is, in patenting process, inventors actually continuously adding to the body of knowledge, right? So what happens even if there is already a patent existing for a particular technology, which belongs, or the exclusive rights of which belong to a particular company or individual, the other inventors, other scientists can work around those existing patents, and create new inventions. So the basic idea or reason behind patenting process is actually to boost research, create more and more inventions by giving this option of giving this opportunity for inventors to get exclusivity for a limited period of time. Then, there's also an option where, so what happens at the end of the day is that the collective knowledge of the public is increased because, inventors, like I said, are constantly adding, more and more inventions are being filed. So the collective knowledge of the public is increased by the number of patents that are filed. Now, as far as universities and public research organizations are concerned, they mostly use these intellectual property rights to create, new products, new processes, and in a lot of cases, they can also create innovative startups based on a patented technology. So, if you have, certain technologies, very key technologies which are niche in the market, then you can create a startup company to market that particular product also. So patenting is a process which actually adds to the body of knowledge, which boosts research and results in creating new inventions. This is basically a graph which actually shows the number of patents that are being filed by universities and public research organizations. As you can see from the graph, India is far ahead of a lot of other countries when it comes to the number of patents that are filed by universities and public research organizations. If you look at the total number of filings, India is way behind a lot of these countries that you can see here. But the number of patents that are filed by universities and PROs, public research organizations, is much higher in countries like India and China. Now, this is actually a very a promising figure because as you can see from the graph, there is a constant growth in the number of patent applications that are filed each year by universities and public research organizations. We as a firm have also filed a lot of patents from a lot of universities and colleges. Very interesting inventions coming up from especially students and faculties in colleges and research organizations. But what we have felt is that a large amount of these scientific and technological advancements that happen in universities and public research organizations, they remain unused because most of them, in most cases, are seen only as academic achievements. Universities or colleges consider patents as academic achievements. Now, this is because these research results or the outcome of these research is not linked to any commercial application. So what is needed at this hour is actually more collaboration or cooperation between universities or the academia or these research institutions and the industry, so that the technology that is developed or researched and developed in these universities is transferred to the industry and the university can benefit from that technology transfer, which we think is a most important need of the hour. Now, this process, which we call technology transfer, can be done in different ways. Like, for example, as a university or as a college, a lot of research happens. You can identify new technologies where research is needed. Then you can do research and development on those particular technologies. It could even be a joint research activity. You can partner with industries. You can partner with other universities after identifying the technology and engage in research activities, which could even be joint research activities. And once the research outcome is, you get the research outcomes, you can patent the technology by filing, or you can protect these technologies by filing the patents. You can jointly own patents. Like, for example, if it is a joint research activity between two universities or two colleges, or between a college and an industry or a commercial establishment, you can file joint applications. And once you file or protect the patents, you can form, you can develop your invention. You can create commercialization strategies. Think about commercializing your invention, such as marketing your product or licensing your product to existing companies and all that. You can also create, like I said earlier, startups which are based on these patented technologies. So what I feel is that, technology transfer is one very important aspect that needs to be also looked into when it comes to patenting by universities and public research organizations, rather than, considering it as a as an academic achievement. Patents should also be the outcome of your research, or research and development should be transferred to the industry, so that the public can benefit. At the end of the day, the public can benefit out of those inventions or those technologies, and the people who put in investments, or who invest on these research, can get benefit or can realize value out of that particular product or the process. So that's all about it. I hope I was able to give you a brief overview on intellectual property rights, patents, and the patent filing procedure, what is patentable, what is not patentable, and also the importance of commercializing your patents or your innovations. Thank you so much for patiently listening to me. I think I have, way over the time that was granted to me. I'm sorry for that. So if you have any questions, you can go ahead. Over to you, Ajmal.
Thank you, Advocate Parvati Prasannan, for that highly informative session. I would like to thank you for the time and effort you invested for this. We take the heart all you have shared with us. We hope all that you have imparted will bear its fruit in due session. Now it's your time for the audience to take the floor. If you guys have any doubts, you can unmute and ask, or you can type in the chat box. Guys, anyone? Excuse me, am I audible?
Yes, Sana.
Yes, you are.
Okay.
Ma'am. Hello.
You can ask your doubts.
കേൾക്കുന്നുണ്ടോ സന?
കേൾക്കാം.
ഓക്കെ മാം, മാം നേരത്തെ പറഞ്ഞിരുന്നല്ലേ ഡു ഇറ്റ് യുവർ സെൽഫ് അപ്രോച്ച് നല്ലതല്ല എന്ന് പറഞ്ഞിരുന്നല്ലേ?
അതെ.
അതെന്തുകൊണ്ടാണെന്നൊന്ന് ക്ലിയർ ആക്കി തരാമോ?
Ajmal, lot of inventors file on their own. പക്ഷെ എന്താ പറ്റണെന്ന് വെച്ചാല്, ഒന്ന് പേറ്റന്റ് ഡോക്യുമെന്റ് അല്ലെങ്കിൽ പേറ്റന്റ് സ്പെസിഫിക്കേഷൻ എന്ന് പറയുന്നത് ഒരു ടെക്നോ ലീഗൽ ഡോക്യുമെന്റ് ആണ്, ജസ്റ്റ് ഒരു ടെക്നിക്കൽ ഡോക്യുമെന്റ് അല്ല. ദർ ഇസ് ലോട്ട് ഓഫ് ലീഗാലിറ്റീസ് ഇൻവോൾവ് ഓൾസോ. നമ്മൾ ക്ലെയിംസ് ഡ്രാഫ്റ്റ് ചെയ്യുന്ന വളരെ കെയർഫുൾ ആയിട്ട് ഡ്രാഫ്റ്റ് ചെയ്യണം. നമ്മൾ പ്രയറായിട്ട് സൈറ്റ് ചെയ്യുന്നത്, ആ സൈറ്റ് ചെയ്ത പ്രയറായിട്ട് നിന്ന് നമ്മളുടെ എങ്ങനെ ഡിഫറെന്റ് ആണെന്നുള്ളത് നമ്മൾ എക്സ്പ്ലെയിൻ ചെയ്യുന്നത് കെയർഫുൾ ആയിരിക്കണം. patents are usually drafted in such a way that you can bypass likely objections. Objections വരുന്നത് avoid ചെയ്യാൻ പറ്റുന്ന രീതിയിലാണ് നമ്മൾ ഡ്രാഫ്റ്റ് ചെയ്യുന്നത്. സോ ഒരു ടെക്നിക്കൽ ഡോക്യുമെന്റ് അല്ല, അതിൽ ലോട്ട് ഓഫ് ലീഗാലിറ്റീസ് ഇൻവോൾവ് ആണ്. അതുകൊണ്ടാണ് ഞാൻ സജസ്റ്റ് ചെയ്തത് എപ്പോഴും ഒരു പേറ്റന്റ് അറ്റോർണിയുടെ ഹെൽപ്പ് എടുത്ത് ചെയ്യണതായിരിക്കും നല്ലത്. സോ ദാറ്റ് വൺ റീസൺ യു ക്യാൻ അവോയ്ഡ് ലോട്ട് ഓഫ് ഒബ്ജെക്ഷൻസ്, റിഫ്യൂസലിനുള്ള ചാൻസസ് അവോയ്ഡ് ചെയ്യാൻ പറ്റും. പിന്നെ വൺസ് അഗെയിൻ വൺസ് ഇറ്റ് കംസ് the examination stage, first examination report ഒക്കെ വന്നു കഴിഞ്ഞാൽ അതിന്റെ റെസ്പോൺസ് ഡ്രാഫ്റ്റ് ചെയ്യുന്നതും വളരെ ക്രിട്ടിക്കൽ ആണ്. ബിക്കോസ് നമ്മുടെ റെസ്പോൺസ് സാറ്റിസ്ഫാക്ടറി അല്ലെങ്കിൽ they can actually refuse your patent application. They can ഹിയറിംഗിന് വിളിക്കുമ്പോഴും you should be able to convince the examiner that this thing will work, because ഞാൻ നേരത്തെ ഒരു പോയിന്റിൽ ഞാൻ പറഞ്ഞായിരുന്നു that you cannot show your prototype. നമ്മളിപ്പോ ഒരു പ്രോഡക്റ്റ് ഒരു ഡിവൈസ് ഉണ്ടാക്കി, നമുക്ക് ആ ഡിവൈസ് കൊണ്ട് എക്സാമിനറിന് കാണിച്ച് ഇത് വർക്ക് ചെയ്യുന്നത് നമുക്ക് കാണിക്കാൻ പറ്റത്തില്ല. നമ്മളുടെ ഡിസ്ക്രിപ്ഷൻ ഓഫ് യുവർ ഇൻവെൻഷൻ ഷുഡ് ബി ഇൻ സച്ച് എ മാനർ that the examiner should be convinced that it will work. നമുക്ക് അത് കൺവിൻസ് ചെയ്യാൻ പറ്റില്ല എന്നുണ്ടെങ്കിൽ it will not be entitled to a patent. So that is very important. അതുകൊണ്ടാണ് ഒരു സ്കിൽഡ് പേഴ്സൺ ഈ ഒരു സ്കില്ലാണ് പേറ്റന്റ് ഡ്രാഫ്റ്റിംഗ് എന്ന് പറയുന്നത്. അതുകൊണ്ടാണ് ഒരു സ്കിൽഡ് പേഴ്സണെ ഏൽപ്പിക്കുന്നതായിരിക്കും നല്ലതെന്ന് ഞാൻ പറഞ്ഞു.
ഓക്കെ മാം, അത് മാത്രമല്ല നമുക്കിപ്പോ ഒരു സ്റ്റാർട്ടപ്പ് ആയിട്ട് രജിസ്റ്റർ ചെയ്യുകയാണെങ്കിൽ പാറ്റന്റിനുള്ള എന്തോ ടൈം ഗ്യാപ്പ് എന്തോ കുറവാണെന്ന് എന്തോ കേട്ടിരുന്നു, അത് ശരിയാണോ?
എന്താ ഞാൻ കേട്ടില്ല, ഒന്നുകൂടെ പറയൂ.
ഒരു സ്റ്റാർട്ടപ്പ് ആയിട്ടാണ് ഞാൻ രജിസ്റ്റർ ചെയ്യുന്നത്, പാറ്റന്റ് അപ്ലൈ ചെയ്യുന്നുണ്ടെങ്കിൽ ടൈം ഗ്യാപ്പ് എന്തോ കുറവാണെന്ന് എന്തോ കേട്ടിരുന്നു. പിന്നെ എന്തോ റീഫണ്ടും കിട്ടും.
അതെ, ഞാനത് ഈ സെഷനിൽ ഞാനത് ഇൻക്ലൂഡ് ചെയ്തില്ല, ബിക്കോസ് കോളേജ് ആയതുകൊണ്ടാണ് ഞാനത് ഇൻക്ലൂഡ് ചെയ്യാത്ത. ഇഫ് യു ആർ എ സ്റ്റാർട്ടപ്പ്, ഒത്തിരി ഗവൺമെന്റ് ഓഫ് ഇന്ത്യയുടെ ഒത്തിരി സ്കീംസ് ഉണ്ട് വിച്ച് യു കെൻ യൂസ് to your benefit. Other onnu parayittu one lot of amendments have been made to the Patents Act and the patent rules to facilitate or to promote more filings of patents by startups. Now patents la one of the major issue ennu parayunnathu delay aanu. Manasila oru patent nammal file cheyda pandokku 4-5 years of edukkuvarunnu kittanayittu. Appo adu affects lot of startups. സ്റ്റാർട്ടപ്സിന്റെ ടെക്നോളജി എന്ന് പറയുന്ന വളരെ നിഷ് ടെക്നോളജി ആയിരിക്കും. അതിന്റെ ലൈഫ് എന്ന് പറയുന്നത് വളരെ ചെറുതായിരിക്കും. അപ്പൊ അവർ കോൺസ്റ്റന്റ്ലി ഇന്നോവേറ്റിംഗ് ആയിരിക്കും. ഇപ്പോൾ 5 കൊല്ലം 6 കൊല്ലം ഒരു പേറ്റന്റ് കിട്ടാൻ തന്നെ എടുക്കുകയാണെന്നുണ്ടെങ്കിൽ അപ്പോഴേക്കും അവരുടെ ടെക്നോളജി ഔട്ട്ഡേറ്റഡ് ആവും. സോ അതുകൊണ്ട് തന്നെ പേറ്റന്റ് പ്രോസസ്സ് എക്സ്പെഡിറ്റ് ചെയ്യാനായിട്ടുള്ള ഒരു പ്രൊവിഷൻ പേറ്റൻസ് സ്റ്റാർട്ടപ്സിനുണ്ട്. സോ ഇഫ് യു ആർ എ സ്റ്റാർട്ടപ്പ് and the patent applicant of the patent is a startup company which is registered under the DPIIT scheme. Government of India DPIIT scheme രജിസ്റ്റർ ചെയ്ത സ്റ്റാർട്ടപ്പ് ആണെങ്കിൽ യു ഹാവ് an option to expedite your patenting process. അതായത് നമ്മൾ പേറ്റന്റ് ഫയൽ ചെയ്ത് കഴിഞ്ഞാൽ എക്സ്പെഡിറ്റഡ് എക്സാമിനേഷൻ, എപ്പോഴും പേറ്റന്റിൽ ഏറ്റവും കൂടുതൽ സമയം എടുക്കുന്ന എക്സാമിനേഷൻ ആണ്. നമ്മൾ റിക്വസ്റ്റ് ഫോർ എക്സാമിനേഷൻ ഫയൽ ചെയ്ത് കഴിഞ്ഞാൽ ചിലപ്പോൾ 2-3 കൊല്ലമൊക്കെ എടുത്തിട്ടായിരിക്കും patent office examination report തരിക. But if you are a startup, you can apply for an expedited examination of your patent. നമ്മൾ expedited examination request ഫയൽ ചെയ്ത് കഴിഞ്ഞാൽ 1 month-നുള്ളിൽ അല്ലെങ്കിൽ 2 months-നുള്ളിൽ നമുക്ക് examination report കിട്ടും. And it is mandatory for the patent office also to clear off that application at the earliest. അപ്പോൾ വേറെ for normal companies it used to take ഇപ്പൊ 4-5 കൊല്ലം എടുക്കുന്ന സ്ഥലത്ത് for startups നമുക്കൊരു 1.5 years-ലൊക്കെ നമുക്ക് പേറ്റൻസ് ഗ്രാന്റ് ആയി കിട്ടിയിട്ടുണ്ട് for startups, because ഈ expedited examination procedure യൂസ് ചെയ്തിട്ട്. again സ്റ്റാർട്ടപ്സിന് ഫീസും കുറവാണ്, ഫയലിംഗ് ഫീസ് കുറവാണ്, റിക്വസ്റ്റ് ഫോർ എക്സാമിനേഷൻ ഫീ എല്ലാ സ്റ്റേജിലും ഫീസും കുറവാണ്. So fee reduction is one aspect for startups. Secondly, this provision for expediting your patent process, adum very helpful procedure aanu. Now apart from that, Government of India oru patent facilitation scheme undu. ആ സ്കീം അനുസരിച്ച് ഗവൺമെന്റ് has notified lot of law firms or patent attorneys as patent facilitators. ഞങ്ങളുടെ firm പുത്രൻ ആൻഡ് അസോസിയേറ്റ്സും ഒരു patent facilitator ആണ്. So if you are a startup, you can use our facility, our firm as a patent facilitator. Now patent facilitation സ്കീമിന്റെ പ്രത്യേകത എന്താന്ന് വെച്ചാൽ, facilitation സ്കീം അനുസരിച്ച് നിങ്ങൾ പേറ്റന്റ് ഫയൽ ചെയ്യുകയാണെങ്കിൽ through a government approved facilitator, നിങ്ങൾ ഫെസിലിറ്റേറ്ററിന് പ്രൊഫഷണൽ ഫീസ് ഒന്നും കൊടുക്കേണ്ടി വരില്ല. നിങ്ങൾ ഗവൺമെന്റ് ഫീസ് മാത്രം കൊടുത്താൽ മതി. ഫെസിലിറ്റേറ്ററിന്റെ ഫീസ് വിൽ ബി റീഇംബേഴ്സ്ഡ് ബൈ ദ ഗവൺമെന്റ് ഓഫ് ഇന്ത്യ. സോ അങ്ങനെ ഒരു പ്രൊവിഷൻ ഉണ്ട്. അപ്പൊ വെരി കോസ്റ്റ് എഫക്റ്റീവ്, ബിക്കോസ് ഫയലിംഗ് ഫീസ് എന്നൊക്കെ പറയുന്നത് ഐ തിങ്ക് ഫോർ സ്റ്റാർട്ടപ്സ് ഇറ്റ് ഇസ് ഓൺലി 1,800 ആണെന്നാണ് എനിക്ക് തോന്നുന്നത് ഫോർ സ്റ്റാർട്ടപ്സ് ടു ഫയൽ എ പേറ്റന്റ് ആപ്ലിക്കേഷൻ. അത്രേ ആവുള്ളൂ നിങ്ങൾക്ക്. പിന്നെ സെർച്ചിന്റെ കോസ്റ്റ് അതിൽ വരില്ല. ബട്ട് പേറ്റന്റ് ഫയലിംഗ് അപ് ടു ഗ്രാൻഡ് എൻറ്റയർ പ്രോസസ്സ് നിങ്ങൾക്ക് ഗവൺമെന്റ് ഫീസ് മാത്രം പേ ചെയ്തിട്ട് നിങ്ങൾക്ക് പേറ്റന്റ് ഫയൽ ചെയ്യാനുള്ള പ്രൊവിഷൻ ഉണ്ട് ഇഫ് യു യൂസ് എ ഫെസിലിറ്റേഷൻ സ്കീം. അതിന് DPIIT രജിസ്ട്രേഷൻ വേണം. വെറുതെ നമ്മൾ സ്റ്റാർട്ടപ്പ് എന്ന് പറഞ്ഞിട്ട് കാര്യമില്ല. DPIIT ഗവൺമെന്റ് ഓഫ് ഇന്ത്യയുടെ DPIITയിൽ രജിസ്ട്രേഷൻ ഉള്ള സ്റ്റാർട്ടപ്പ് ആയിരിക്കും.
മനസ്സിലായി മാം. ഒരു ക്വസ്റ്റ്യൻ കൂടി ഉണ്ട്, ചോദിച്ചോട്ടെ?
ചോദിച്ചോളൂ.
മാം പറഞ്ഞിരുന്നു, എനിക്കൊരു ക്ലാരിഫിക്കേഷൻ വേണ്ടി മാത്രമാണ്. നേരത്തെ പറഞ്ഞിരുന്നു പബ്ലിഷ് ചെയ്യരുതെന്ന് പറഞ്ഞിരുന്നു. പക്ഷെ അതിന്റെ തൊട്ടപ്പുറത്ത് തന്നെ മാം പറഞ്ഞു ലാബിന്റെ ആവശ്യങ്ങൾക്ക് വേണ്ടി പബ്ലിഷ് ചെയ്ത് കഴിഞ്ഞിട്ടുണ്ടെങ്കിൽ അങ്ങനെ എന്തോ ഒരു റിലാക്സേഷൻ ഉണ്ടെന്ന് പറഞ്ഞു.
അതെ, ലാബിന്റെ ആവശ്യത്തിന് പബ്ലിഷ് ചെയ്യാൻ ഇപ്പൊ നമ്മൾ ലാബിൽ വർക്ക് ചെയ്യുന്നതിനൊന്നും കുഴപ്പമില്ല. പക്ഷെ നമ്മളൊരു ജേർണലിലൊക്കെ സയന്റിഫിക് ജേർണലിലൊക്കെ പബ്ലിഷ് ചെയ്ത് കഴിഞ്ഞാൽ
ഓക്കെ. സയന്റിഫിക് ജേർണൽ അല്ലാണ്ട് വേറെ ഏതെങ്കിലും ജേർണൽ ആണെങ്കിൽ ഇപ്പൊ നമ്മുടെ സോഷ്യൽ മീഡിയാസ് ഒക്കെ ആണെങ്കിലോ?
ഡിഫിക്കൽട്ട് ആണ്. ഇപ്പോ പേറ്റന്റ് ഓഫീസിൽ എക്സാമിൻ ചെയ്യുന്ന സമയത്ത് പേറ്റന്റ് ഓഫീസ് കാണുകയാണ് ഓൾറെഡി പ്രയർ പബ്ലിക്കേഷൻ. അങ്ങനെയാണെങ്കിൽ ഇറ്റ് കൻ അഫക്ട് ദി നോവൽറ്റി ഓഫ് യുവർ ഇൻവെൻഷൻ. നമ്മൾ ഓൾറെഡി ഒരു ഫയൽ ചെയ്യുന്ന സാധനം നമ്മൾ വളരെ ഡീറ്റെയിൽ ആയിട്ട് നമ്മൾ എന്താണോ ക്ലെയിം ചെയ്യുന്നത് ആ ക്ലെയിം ചെയ്യുന്ന സാധനം ഓൾറെഡി ഡിസ്ക്ലോസ്ഡ് ആണ്. അത് എവിടെയാണെങ്കിലും if the patent office finds that out, it can affect your novelty.
ജസ്റ്റ് ഒരു ഗ്ലിംസ് മാത്രമായിട്ട് ഇട്ടാലോ? എനിക്കൊരു അവയർനെസ് എനിക്ക് വേണം, എനിക്ക് അറിയണം, ആൾക്കാർക്ക് ഇത് ആവശ്യമുണ്ടോ ഇല്ലയെന്ന് വേണ്ടി അറിയണം, അതിനുള്ള അവയർനെസ്.
അത് കുഴപ്പമുണ്ടാവാൻ വഴിയില്ല, അതൊന്നും വലിയ പ്രശ്നം ഉണ്ടാവാൻ വഴിയില്ല. കാരണം വെച്ചാൽ നമ്മള് പേറ്റന്റ് ഒരു പേറ്റന്റ് ടെക്നോളജിക്കാണ്, അതിന്റെ വർക്കിങ്ങിനാണ് നമ്മൾ ആ വർക്കിംഗ് ഒന്നും ഡിസ്ക്ലോസ് ചെയ്യാതിരുന്നാൽ മതി.
ഓക്കെ. ഇപ്പോ എനിക്ക് ജസ്റ്റ് അറിയണമായിരുന്നു എന്താണ് അത് ആൾക്കാർക്ക് യൂസ്ഫുൾ ആണോ ജസ്റ്റ് അറിയണമായിരുന്നു. അങ്ങനത്തെ ഒരു കേസിന്
വേണ്ടിയിട്ടാണ് ഇഷ്യൂ ഉണ്ടാവാൻ ചാൻസ്. ഡിസ്ക്ലോഷർ കണ്ടാലേ ഞങ്ങൾക്ക് പറയാൻ പറ്റും whether it will affect നമ്മൾ പേറ്റന്റ് ഡ്രാഫ്റ്റ് ചെയ്ത് കഴിയുമ്പോൾ നമുക്ക് നമ്മൾ എന്താ ക്ലെയിം ചെയ്യുന്നതെന്നും ആ ക്ലെയിം ചെയ്യുന്ന സാധനം ഡിസ്ക്ലോഷറിൽ ഉണ്ടോ എന്ന് നോക്കിയാൽ മതി.
ഓക്കെ ഓക്കെ, താങ്ക് യു മാം.
താങ്ക് യു.
Ma'am, adding to that, I have a question because mostly in engineering colleges, our faculty and students are having a practice that they publish their works in reputed journals or conference proceedings soon. So even if it is their own work, is it not patentable after that?
Yes, ഞാൻ നേരത്തെ പറഞ്ഞല്ലോ, നമ്മൾ തന്നെ പബ്ലിഷ് ചെയ്താലും it becomes a non patentable invention because novelty ഇല്ല അതിന്. അതുകൊണ്ട് എപ്പോഴും അഡ്വൈസബിൾ എന്ന് പറയുന്നത് you assess the patentability. For എല്ലാ inventions, like I said earlier, all inventions may not be a patentable invention. If there is a scope for patent, it's always better to assess the patentability and file a provisional application at least and then publish the invention. ഞാൻ പറഞ്ഞല്ലോ നമുക്ക് പേറ്റന്റ് ഫയൽ ചെയ്യുമ്പോൾ ഫുൾ ഡിസ്ക്ലോഷർ കൊടുക്കണം എന്നില്ല. പ്രൊവിഷണൽ ആപ്ലിക്കേഷൻ, you file a provisional application and then you go public your invention, publish your invention, and then within 1 year you can file the complete disclosure.
Okay, ma'am.
Okay, ma'am, നമ്മൾ മെയിൻ ആയിട്ട് യൂസ്.
Ma'am, there is one more question in the chat box from Jidin Azizi that can I obtain a patent for a software related invention?
Okay, software related, in one of my earlier slides, like I said earlier, computer software per se, algorithms, computer software per se is not patentable. Computer software is, comes and is categorized under copyright. Copyright protection ആണ് പറയുന്നത്. But a computer software that has a technical application may be a patented invention. There are a lot of software related inventions in India. There are also guidelines published by the patent office for computer related inventions or software related inventions. So if you ask me, yes, software related inventions are also entitled to patent, provided there is some technical application for the invention. Software per se, any ഒരു സോഫ്റ്റ്വെയർ പേറ്റന്റബിൾ ആവണം എന്നില്ല. അതിന്റെ ആപ്ലിക്കേഷൻ ഡിപെൻഡ് ചെയ്ത്, application is technical, then yes.
Okay, thank you, ma'am.
Thank you.
മാം, ഒരു കാര്യം കൂടെ ചോദിച്ചോട്ടെ?
Yes, sir.
One last. നമ്മൾ സാധാരണ ഗൂഗിൾ പാറ്റേൺസ് ആണ് മെയിൻലി യൂസ് ചെയ്യാറ് ഇങ്ങനെ എന്തെങ്കിലും സെർച്ച് ചെയ്യണമെങ്കിൽ ഒക്കെ. അല്ലാണ്ട് വേറെ ഏതെങ്കിലും സൈറ്റ്സ് മാമിന് റെക്കമെൻഡ് ചെയ്യാനുണ്ടോ കുട്ടികൾക്ക് വേണ്ടി?
ഞാൻ നേരത്തെ ഐ തിങ്ക് ഒരു സ്ലൈഡിൽ ഞാൻ പറഞ്ഞിരുന്നു, ഇന്ത്യൻ പേറ്റന്റ് ഓഫീസിന്റെ ഡേറ്റാബേസ് ഇൻപാസ് എന്ന് പറയും, INPASS, ഇൻപാസ് പേറ്റന്റ് സ്കോപ്പ് എന്ന് പറയുന്ന വൈറ്റ് ബോർഡ് പേറ്റന്റ് ഡേറ്റാബേസ്. eSpaceNet, which is European Patent Office
മാം അത്
database.
ചാറ്റ് ബോക്സിൽ ഇട്ട നന്നായിരുന്നു.
ഇതെല്ലാം ഫ്രീ ഡേറ്റാബേസസ് ആണ് കേട്ടോ. അപ്പൊ ഇതെല്ലാം you can access. Just to Google ചെയ്തെടുത്താൽ മതി. eSpaceNet European Patent Office, then patent scope. This is the second one is the database of WIPO, World Intellectual Property Organization. Then INPAS, that of India, and then USPTO.
Thank you.
USPTO is also a free database.
ഹലോ മാം കേൾക്കുന്നുണ്ടോ?
കേൾക്കാം, അമൽ പറഞ്ഞോളൂ.
മാം ഇപ്പൊ ഒരു കമ്പനിയിൽ വർക്ക് ചെയ്യുന്ന ഒരു എംപ്ലോയി ഇപ്പൊ ഒരു പുതിയൊരു ഇൻവെൻഷൻ കണ്ടുപിടിച്ചു എന്ന് വെച്ചാൽ അതിന്റെ പേറ്റന്റ് റൈറ്റ്സ് പോകുന്നത് ആർക്കായിരിക്കും? എംപ്ലോയിക്കായിരിക്കും അതോ കമ്പനിക്കായിരിക്കോ?
നോർമൽ കേസിൽ ഇപ്പൊ നമ്മളൊരു കമ്പനിയുടെ എംപ്ലോയി ആണെങ്കിൽ കമ്പനി ആയിരിക്കും പേറ്റന്റ് ആപ്ലിക്കന്റ് എന്ന് പറയുന്നത്. അതിൽ എംപ്ലോയീസ് ഹൂഎവർ ഡെവലപ്ഡ് ഡെവലപ്ഡ് ഇൻവെൻഷൻ അവരെ ഇൻവെന്റേഴ്സ് ആയിട്ടായിരിക്കും നെയിം ചെയ്യുന്നത്. അപ്പൊ പേറ്റന്റിന്റെ ആപ്ലിക്കന്റ് ആയിരിക്കും, ആരാണോ നമ്മൾ ആപ്ലിക്കന്റ് ആയിട്ട് നെയിം ചെയ്യുന്ന അതായിരിക്കും ഓണർ ഓഫ് ദ പേറ്റന്റ്. ഇൻവെന്റേഴ്സിന് ആ ഒരു ക്രെഡിറ്റ് മാത്രമായിരിക്കും. പിന്നെ ഇത് ഡിപെൻഡ്സ് ഓൺ ദ കമ്പനി പോളിസി ഓൾസോ കേട്ടോ. ഇപ്പൊ യൂണിവേഴ്സിറ്റീസ്, റിസർച്ച് ഓർഗനൈസേഷൻസിനൊക്കെ അവർക്കെല്ലാവർക്കും ഒരു ഇന്റേണൽ പോളിസി ഉണ്ടാവും. മോസ്റ്റ് ഓഫ് ദ കേസസിൽ യൂണിവേഴ്സിറ്റീസ് ആൻഡ് കമ്പനീസിലെല്ലാം ഓണർ ഓഫ് ദ പേറ്റന്റ് വിൽ ബി ദ യൂണിവേഴ്സിറ്റി ഓർ ദ കമ്പനി, ആൻഡ് ഇൻഡിവിജ്വൽസ് വർക്കിംഗ് ഓൺ ഇറ്റ് വിൽ ബി അവരെ ഇൻവെന്റേഴ്സ് ആയിട്ട് അതിൽ നെയിം ചെയ്യും. നിങ്ങൾക്ക് ക്രെഡിറ്റ് ആണ് വരിക ഇൻവെന്റേഴ്സ് ആയിട്ട്.
Ma'am, is joint application is possible, right?
Yes, it is possible. Ipo a lot of companies file in the joint name. കമ്പനിയും ഇൻവെന്ററും കൂടെ ജോയിന്റ് ആയിട്ട് അപ്ലൈ ചെയ്യാം. ജോയിന്റ് ആപ്ലിക്കേഷൻ പോസിബിൾ ആണ്.
Yes, okay.
മാം പറഞ്ഞല്ലോ ഫയൽ ചെയ്യാനായിട്ട് ഇപ്പൊ ഒരു അറൌണ്ട് 1800 അല്ലേ മാം ചാർജ് വരുന്നത്?
അതെ, സ്റ്റാർട്ടപ്പ് ആണെങ്കിലാണ്.
അപ്പോ ഈ 2 years കഴിഞ്ഞിട്ട് ഇതിപ്പോ നമ്മുടെ പാറ്റന്റ് ഇപ്പൊ 20 yearsലേക്ക് ആനുവലി ലൈവ് ആക്കി വെക്കാനാണെങ്കിൽ എങ്ങനെയായിരിക്കും ചാർജ് വരാ?
അതിന്റെ ഫീസ് ഡിപ്പെൻസ്. ആദ്യത്തെ 5 years ഒരു ഫീസ്, പിന്നത്തെ നെക്സ്റ്റ് 5 years ഒരു ഫീസ്, ആൻഡ് ഇറ്റ് ഇൻക്രീസസ്, കീപ്സ് ഓൺ ഇൻക്രീസിങ്. 20th year ഒക്കെ ആകുമ്പോൾ ഫീസ് ഇച്ചിരി കൂടുതലാണ്. ബട്ട് ഇപ്പോഴത്തെ റീസെന്റ് അമെന്റ്മെന്റ് അനുസരിച്ച് സ്റ്റാർട്ടപ്സിന് അതിലും റിഡക്ഷൻ ഉണ്ട്.
ഓക്കെ, താങ്ക് യു.
Okay.
Anchors, so you can continue the session.
Any
Sanna.
more doubts?
മാം, വൺ മോർ ക്വസ്റ്റ്യൻ.
പറഞ്ഞോളൂ.
മാം, നമ്മളിപ്പോ പാറ്റന്റ് ഫയൽ ചെയ്യാനേക്കാൾ മുന്നേ നമ്മുടെ ഒരു ഐഡിയ എന്ന് പറയുന്നത് ഒരു പൊട്ടൻഷ്യൽ ഇൻവെസ്റ്റർ ആയിട്ട് ഡിസ്കസ് ചെയ്യുമ്പോൾ അതിന്റെ അഭിപ്രായം?
ഓക്കെ, നോർമൽ കേസിൽ നമ്മളൊരു പൊട്ടൻഷ്യൽ പേറ്റന്റിന് സ്കോപ്പ് ഉള്ള ഒരു ഇത് നമ്മൾ എവിടെയെങ്കിലും ഡിസ്ക്ലോസ് ചെയ്യുകയാണെങ്കിൽ നമ്മൾ വി ഓൾവേസ് അഡ്വൈസ് ഡിസ്ക്ലോസിങ് ഇറ്റ് അണ്ടർ സം എഗ്രിമെന്റ്. ഒരു നോൺ ഡിസ്ക്ലോഷർ എഗ്രിമെന്റ് ഒക്കെ വെച്ചിട്ട് ഡിസ്ക്ലോസ് ചെയ്യുന്നതാണ് നല്ലത്. ബിക്കോസ് ചാൻസസ് ഓഫ് മിസ്യൂസ് ഉണ്ട്. ലോട്ട് ഓഫ് ഇൻസ്റ്റൻസസ് വേർ ഇപ്പൊ കോൺട്രാക്ട് മാനുഫാക്ചറിങ്, നമ്മളൊരു സാധനം ഒരു ഇൻവെൻഷൻ ഉണ്ടാക്കിയിട്ടുണ്ട്, അത് മാനുഫാക്ചർ ചെയ്യണമെങ്കിൽ ഒരാളെടുത്ത് ഡിസ്ക്ലോസ് ചെയ്താലേ പറ്റുള്ളൂ. അയാള് ഇത് സാധനം വേറെ ഉണ്ടാക്കി കഴിഞ്ഞാൽ അല്ലെങ്കിൽ അയാൾ അത് കൊണ്ട് ഫയൽ ചെയ്ത് കഴിഞ്ഞാലൊക്കെ നമ്മൾ എഫക്ട് ചെയ്യും. അതുകൊണ്ട് നോൺ ഡിസ്ക്ലോഷർ എഗ്രിമെന്റ്സ്, NDA എന്ന് പറയും, ഒരു എഗ്രിമെന്റ് വഴി, സോ ദാറ്റ് you can make sure that it is kept confidential, it is not disclosed to anyone. അങ്ങനെ എന്തെങ്കിലും എഗ്രിമെന്റ് ഒക്കെ വെച്ചിട്ട് ചെയ്യാൻ പറ്റുകയാണെങ്കിൽ നല്ലത്.
ഓക്കെ, താങ്ക് യു മാം.
Thank you.
Okay. Moving on, we're looking forward to your feedback. We welcome your comments or remarks about the program.
Good afternoon. The session was extremely useful. The materials was interesting and the discussions were truly inspiring. We could know about what's the difference between copyright and patent filing procedures, and prior searching general informations about patents. For me, it was a new info that there are not patentable inventions also. Thank you, ma'am. Thank you for the fabulous session. On behalf of all students, thanks to everyone who was involved and preparation and execution of the session. We look forward to attend sessions like this. Thank you.
Thank you, Anaka. Now I invite Mr. Ajmal C. Rashid, IEDC Chief Executive Officer, to express deep gratitude on behalf of IAS College of Engineering.
Thank you, Jasna. I, on behalf of ISIDC and IEEE, extend a very hearty vote of thanks to our esteemed Chief Guest, Ms. Parvati Prasannan, for gracing this event. It has been an honor for each one of us to hear those valuable words from you. Thank you, ma'am. Now,
Thank
I
you.
must mention our
Thank you.
deep sense of gratitude towards our beloved principal, Dr. B.S. Sangeeta, and the management of IEC for their support for organizing this event. Next, I am using this opportunity to thank HODs of various departments and faculties for their support. Next, I would like to thank IES Nodal Officer Ajishas, Assistant Nodal Officer Parvati P, IEEE Student Chapter Mentor Sarin Sir, for their guidance. I also wish to express my appreciations to the whole IEDC and IEEE team working behind, making this event a grand success. Last but not the least, I would like to thank each and every individual here for their sincere cooperation. Thank you.
Thank you, Ajmal. Audience, please note, you will find a link to feedback form in the chat box. Take a moment to fill it up, please. It was nice to meet you all. Hope you guys enjoyed it and let it be an advancement in your career. Before we sign off, we have an important announcement. A significant program is lined up for us tomorrow, 10:30 a.m. Academic project Ideation to Startup. We invite your presence. See you all tomorrow. Bye. Thank you, everyone.
Thank you.
Thank you, ma'am. Thank you.
Bye.
Bye.